Hello, this is Jeff Wild, and I'm once again interviewing my illustrious nephew, the managing partner of Wild Felice and Partners, Michael D. Wild. Michael, as I said, is managing partner of Wild Felice and Partners. It's a Fort Lauderdale-based estate planning, asset protection, and probate administration law firm. And Michael, I do have some questions for you. But first, how are you?
Doing great. How are you doing?
Oh, doing just fine. I'm going to try to see without my glasses so I don't reflect on the screen. Anyway, I have some questions to ask you, and today I want to ask you questions about estate planning. First off, what is it? What is estate planning?
Well, it's funny. Whenever you use the term estate planning, people get confused. I've heard some people say, "Oh, you work for the state?" No. It has nothing to do with the state. It's estate planning. And then other people, they hear the word estate and they think it's for millionaires. The word we really want to focus on is planning. Everyone has an estate. I have an estate. You have an estate. People living under a bridge have an estate. The question is whether we plan or not to help that estate go to the people we want it to go to rather than to the state or to some other source of creditor or litigant or somewhere we don't want our money to go. So estate planning is basically the planning for the management of ourselves and the assets that we own.
Okay. Basically, I'm still confused, but that's only because I live under a bridge. Now I do have some serious questions, though. A lot of people have drawn up a will, and I understand that wills are not completely adequate. And I've heard the term trust thrown around quite a bit. What is the difference between a will and a trust?
Well, that's a great question. It's a cause of a lot of confusion. There are a lot of documents that all have similar names that nobody really understands what each one does. A living will, a living trust, a last will and testament, and people don't understand that each document really does its own thing. Now, a will is given to you by the state if you don't have one. That's the one document where if you don't describe how you want your assets to be distributed when you die, the state will describe how they want your assets to be distributed when you die. And so it's not ideal, but you will have a will eventually. The only reason to just have a will is if you don't have any assets, but you do have minor children. So if you have minor children, and you want to put a guardian in place, but you're renting your apartment, you're leasing your car, you're living paycheck to paycheck, that's fine for now. You can put a will in place and you can at least have that guardian in place for those minor children. But that's pretty much all a will does, because a lot of people think wills avoid probate. They do not, and probate is the transferring of assets through the court system from the deceased person to the living beneficiaries. All wills must be probated. In fact, probate is the proving of the will. The only way to avoid probate and to actually add protection for those beneficiaries is to use a living trust. Now, there are many different types of trusts, both revocable and irrevocable. The type I just want to talk about today is the revocable living trust. The living trust works in concert with the will, so it's not something that is in a vacuum. The will helps to fund the trust. The trust then has all of the assets. The assets avoid probate. They will reduce or eliminate estate tax. They will allow for asset protection for all of the beneficiaries, and they will allow the grantor, the person who creates the trust and gives to the trust, to control assets in Florida for up to 360 years after they die, which means that for all those people concerned that I might give something to my daughter and then my son-in-law ends up with it, he won't. You'll be able to give assets directly to your children, then your grandchildren, then your great-grandchildren, or anyone else you want to give it to, charities or friends, whatever you want. But you'll be able to control where those assets go long after you're gone.
Interesting. Question.
Mm-hmm.
As a person who lives under a bridge, I have to ask, why would someone who isn't wealthy, who isn't a millionaire, be needing a trust?
Well, and that's a good question, because there's some confusion as to estate planning versus tax planning. And both are necessary for some people. We have clients that, like I said, don't have $2 to rub together. We also have clients that have 30, 40, $50 million and above. Even the clients that have a ton of money never put tax planning as their number one goal. There's always control or asset protection, or just making sure that the administration is easy for my children and that they don't fight. Maybe privacy, that's another issue. Trusts are private, wills are public, wills become public record. So there's always a different reason why people use a trust. But the fact is that a trust is not much more expensive than a will, but it provides a lot more benefit. A will does not really do anything except describe how to distribute assets, whereas a trust, even for someone who is, would be considered to be a middle class to low middle class, would still get benefit from using a trust beyond the asset protection, beyond the control, beyond the probate avoidance. The idea of privacy, the idea of ease, those are things that are so important to most people. And to know that you can get that for just a few $100s more than a will, and know that your family is going to be protected after you're gone, it doesn't really matter whether you have $1 billion or $1,000. Now back to the probate issue. Probate kicks in at $75,000. So where most people think, oh, you only have $1 million, or you don't have $5 million, or whatever the tax number is, so you don't need a trust. Actually, anyone with over $75,000 in total assets, including a home, they're going to have to go through probate. So anyone with over $75,000 in assets is going to benefit from having a trust in place.
I understand, and even I require a trust. That bridge property is very, very valuable. Seriously, though, what other documents are included in estate planning in addition to wills and trusts?
Sure. Well, when everyone thinks about estate planning, the first thing they talk about is death. In reality, obviously the death rate in Florida is 100%. So everyone knows they're eventually going to die. Even Moses died after 200 years. So we know that those documents will be used. The will and the trust will be used. But some other documents that are really important, two documents that go along with the will and the trust. One is a deed. So any real estate should be put into the trust to fund that trust. And the other document is an assignment of property to trust, also called a quitclaim bill of sale. Allows for all personal property, vehicles, watercraft, all of those assets to be put into the trust also without having to change title. But beyond the death documents, we want to talk about incapacity too, because there's a very good chance that if you live long enough, you're going to be incapacitated for at least some period of time, either voluntary or involuntarily. And you need to put someone in place to manage your financial affairs, to manage your healthcare decisions, things like that. So the 4 documents that we call the under the bridge documents, because the supplemental documents that are required for anyone, no matter how much assets, how much or how little in assets they have. The durable power of attorney, which allows for someone to make financial decisions on your behalf if you can't make them for yourself. The designation of healthcare surrogate, again, someone, and it doesn't have to be the same person, someone that can make healthcare decisions, and maybe that's as simple as authorizing a knee surgery when you're too high on Vicodin to do so yourself. Then we've got the HIPAA release, very important document, allows for that surrogate to view your medical records. Without the HIPAA release, even a married couple can't see each other's medical records, MRIs, X-rays, things like that. And then the living will. The living will, also sometimes known as the advance directive, everyone remembers in Florida, back in 2005, the big Terry Schiavo Supreme Court case. At the end of that case, the Supreme Court had decided that without a correctly executed living will, doctors must keep the patient alive artificially, even if they're on life support, even if they're brain dead, even if they're a vegetable. So in order to avoid that and having funds depleted and angst and worry from the family, you sign the living will and you put that in place, and it says, I do not want to be kept alive artificially in the case that I am brain dead or on life support. So those documents are necessary for all clients. We hope you never have to use any of them, but if you need them and you don't have them, it's too late to get them.
Thank you. I know that you know that I'm a teenager who's prematurely gray. And as such a young person, Um, should I be concerned with estate planning? I mean, seriously, how old do you have to be considering a proper estate plan?
Sure. Another misconception about estate planning is that there is an age contingency, or that you have to wait to a certain age, or you don't need it until a certain age. Just like the idea of, oh, well, I don't have enough money, so I don't have to worry about it. If age is not discriminatory when it comes to death. Obviously, people that live to 95 years old, every day they wake up and they're surprised, and someone like myself who's 34 years old, I might assume that tomorrow I will wake up just because I take it for granted. But 25-year-olds die all the time, and 90-year-olds live to be 100. So there's no real way to know when we're going to die. In fact, if there was a way, I'd make a lot of money in that business rather than in the estate planning business. But what we want to do is we want to make sure that the family is protected. I always say that it's not an age thing, it's not an asset thing, it's a beneficiary thing. So if I'm 90 and I have $9 billion, but I don't have any family, I don't have any charitable intent, I don't have any person to leave it to at all, well, who cares if the government takes half of it? Who cares if I'm unprepared? It doesn't really matter because there's nobody to leave it behind to. But as myself, 34 years old, stay-at-home wife, mortgage on my house, second child on the way, estate planning is crucial for me. Because if I died tomorrow and I didn't have estate planning, I didn't have life insurance, I didn't have protection for my family, well, that could be a crippling event that they never recover from. That could be something that forces my wife to have to go back to work, even with an infant at home, or even worse, in her mind, to live with my mother. And it would really just...
your mother. I love your mother.
I love my mother too. You got to talk to my wife. But it could force a series of events that just leads to the downfall of a family. So my feeling is estate planning is even more important for younger families with minor children. Putting guardians in place, protecting surviving spouses. It's even more important for them than it is for the older generations, which are preparing for death more often because they're expecting it sooner. But the surprise death is usually more crippling than the expected.
Yeah, I can imagine. Yeah, aside from the trauma of having to live with in-laws, describe some mistakes that people make in their estate plan.
Absolutely. I do free reviews, so I get to see a lot of different types of estate plans. A lot of mistakes are made by people who try to do it themselves, which always amazes me because you only die once. So if you do it wrong the first time, there's no way to correct that later on. You do your taxes wrong, and the IRS gives you 3 years to amend. You do your estate planning wrong, and unless you can resurrect, there's really no way to go back and fix it. So that's the biggest mistake, is the idea of do it yourself. Do it yourself heart surgery? No way. Do it yourself estate planning? For some reason, people think it's okay. But some of the common mistakes that even attorneys make when I review these are amazing. For instance, sometimes people think that it's okay, well, I'm just going to put my son on my house, and then that way when I die, my son just gets it. That's one of the biggest mistakes I see among especially retirees. They put their kids on their house because their kids are grown, and they figure, okay, that's a great way to avoid probate. The problem is, number one, as soon as you deed a half interest of that property to your child, you've given a gift of a half value of your property, which means you owe gift tax on that. You're only allowed to gift $13,000 to any one person in any 1 year. So if you've given more than $13,000, if you live in a house worth more than $26,000, which nowadays who knows, but then you've given a gift that you need to pay gift tax on, and the IRS, if they catch you, will levy a penalty. Now, in addition to that, when you die, there's something called a step up in cost basis. If you do through a will or a trust, if you deed property through a will or a trust, the property steps up to the value as of date of death, or 6 months after date of death, whichever the person chooses. And then when you sell the property, if you sell it for that fair market value, you pay zero capital gains tax. The beneficiary would pay zero capital gains tax. However, if you transfer a property during life, the person who receives that property, they take the cost basis of the initial purchaser. So if you owned a property for 40 years, if you've lived there for 40 years, you probably bought it for, let's say, $50,000, and maybe now it's worth $400,000. Well, now you owe $70,000 in capital gains tax when you sell it. So that's another issue, is they don't take into account the gift tax, they don't take into account the capital gains tax. In addition, when you put someone's name on your property, you're doubling the liability. So let's say that you live in a house and you've homesteaded that house. Florida homestead protection is fantastic. It's constitutionally protected. So you think you're okay, but you put your son's name on the property. Well, now your son gets in a car crash and they sue, and the lawyer suing is trying to figure out, well, what property does this guy own? Well, the half interest in your house that he owns is not protected. So a lien could be put against your house where it otherwise would have been protected from all liens other than liens arising out of the house. So that's another issue, asset protection. And then from the other side of that, I even had one client that came in. His mom put his name on her house. He was trying to file bankruptcy. He had no assets. The bankruptcy court rejected the bankruptcy because they said he did have an asset, a half interest in her house. So all of these things come into play. And in addition, when the asset transfers at death, if the person whose name is on the deed doesn't do something with it at that point, then the asset would eventually be probated and end up with that person's spouse or that person's creditors or somewhere else. So that is one of the biggest mistakes I see people make. And the rule of thumb is, if you're not married to the person, don't own something with them. So there is good reason, sometimes not good reason, for husband and wife to own assets together. But if you're not married to the person, you should never own anything with them. There are other ways to allow children to have access to assets without giving them ownership. Now, another big mistake I see people make is they go and they get this trust made, and the trust is done correctly. It's beautiful, but they don't fund it. A trust is like a safe. Imagine making this fireproof, waterproof, burglar-proof safe. You drill a hole in the master bedroom closet floor and you put it down there, you put carpet over it, but all your valuables are on the dresser. Doesn't make any sense. So what we have to do, and what we walk our clients through, is once the trust is created, once that safe is there, we have to take the assets, the house, the bank accounts, the brokerage, the retirement, the life insurance, make sure they all flow into that trust. So that way that trust protects those assets. Another huge mistake is not updating the estate plans. Estate plans are not made by Ron Popeil. They are not set it and forget it. They need to be tuned up every now and again. If you think about what your family looked like 15 years ago versus what your family looks like now, it's different. People are different. Assets are different. Concerns are different. So if everything changes over a period of 15 years, why would you wait 20 years before updating your estate plan? So I tell my clients every 3 to 5 years we do a little tune-up. We check it for changes in the law, we check for changes in the assets, and then I ask my clients, did anyone in your family or named at all in these documents die, have a baby, get married, or get divorced? Because that could change everything. I mean, you yourself had 3 years ago had a minor child and now have a child of majority. So it changes everything.
Michael, it sounds like an estate planning attorney is the only way to make sure that your assets are covered. Can you tell me, I remember you telling me horror stories about some famous people who did not cover their assets properly.
Sure.
Can you maybe tell the audience 1 or 2 horror stories that are, some were amusing, some were horrible?
Absolutely, absolutely. One of them, you say assets, and this celebrity immediately comes to mind, and that's Marilyn Monroe. And Marilyn Monroe, beyond the assets that everyone appreciated her for, had an estate of about $800,000 when she died. Now, back when she died, intellectual property, patents, trademarks, likenesses, things like that, wasn't a big deal. So she felt like she didn't have a huge estate. She didn't have children to leave the estate to. She left everything outright to her acting coach. And that was fine with her, except because it was a will and because it was left outright, the acting coach then got married to a young bride who never met Marilyn Monroe. Those assets, when he died, because he didn't have any estate planning either, went to his wife, then the young girl that he had married. Now, she got some good advice, and she put a trust in place. Her grandchildren right now own Marilyn Monroe's estate, which is worth today $30 million. And they sue everybody who uses her likeness. Now, they never even met her, and they control the entire estate and are able to sue on behalf of the estate. And that's one of those situations where I always point out to clients, after you're gone, you should still be concerned with who's getting the assets. It shouldn't be someone you never met. It should be a family, a friend, or at least a charity that means something to you. So Marilyn Monroe's a big one. Elvis is another one. Elvis lost 73% of his estate to probate fees and estate tax when he died. Now, Priscilla and Lisa Marie are doing just fine because the royalties to Elvis songs are still playing every day on commercials and TV shows, so they're going to be fine. In fact, a lot of musicians, because of the royalties, even with the mistakes, they ended up okay. But some of the people that were not musicians were not so lucky. Joe Robbie is one that's very famous in South Florida. Joe Robbie was the owner of the Miami Dolphins and Joe Robbie Stadium that he built himself with his own money. Very successful businessman, but for some reason did not have an estate plan in place, did not have life insurance. The rumors were that he had a younger wife and thought that she would just take care of it. Well, she died 3 months after him. The other rumor was that the attorney had the documents ready and just Joe Robbie never got around to signing it. He was too busy. Well, Joe Robbie died in 1990. There was a $47 million estate tax bill. The kids had no liquidity. They just had the team, the stadium, and maybe $10 million. They couldn't deal with the fee that was coming from the IRS. Now, the IRS has no interest in being a partner in an NFL franchise, nor do they have an interest in allowing you a payment plan to pay. You actually have 9 months from the date of death to pay the estate tax. Well, they couldn't come up with $47 million, so Wayne Huizenga, bless his heart, came in, offered a bargain basement price for the team and the stadium, ended up actually selling it, bought the team for $100 million, sold it for $1 billion not too long ago, and even kept a percentage of it. So he's a really shrewd businessman. I guarantee he has an estate plan in place. Joe Robbie's family lost the team, lost the stadium, ended up with a few $1 million, which is fine if you didn't start with a net worth of $120 million. And now, even 23 years later, the Dolphins were trying to get funding, city funding, state funding, to renovate the stadium, and are threatening, because they didn't get that funding, to move. So 23 years ago, Joe Robbie failed to put a trust in place, and today the South Florida area could lose its only professional football franchise, the Miami Dolphins, because they're threatening to move. So estate planning affects everybody.
Wow. These are great stories and definitely some very good reasons to contact an estate planning attorney. And I would suggest that everyone in South Florida contact Wild Felice and Partners. Michael, how about telling our viewers how to reach you?
Sure. Well, there are a couple ways you can reach me. You can always call me. The office number here locally is 954-944-2855. And you can speak with me by hitting extension 1, or any of the attorneys here are wonderful as well. And you can also contact me by visiting our website at southfloridawills.com or wfplaw.com. And you can email me directly if you'd like at mwild@wfplaw.com. And I should point out, we do free consultations, we do free reviews, and we do fixed fee billing. So people that are concerned of, oh, well, I've always heard you go to an attorney, and sure, then you talk about the will and you talk about the trust, and you come in to adjust things, and you get a bill in the mail for $85,000. Well, it doesn't quite work like that. What we do is, during the free consultation, we review any documents you might have already. If you don't have any documents, that's fine. It's just a conversation at that point. It takes about an hour. At the end of that hour, we've come up with a diagnosis. We try to accomplish all the goals that you want to accomplish. I will quote a fee. That fee is fixed. So if it takes me more time or we need more meetings, that fee does not go up. Fixed fee billing tends to put the attorney and the client on the same side of the table. So free consultations and fixed fee billing, you'll find that from all of our attorneys here.
Thank you, Michael. Thank you very much for this interview. Right now, the city is about to run their trucks under my bridge, so I'm going to have to end this interview. And by the way, I know that your wife loves your mother. So And so I don't think it would be so bad if she and the kids had to move in with her. Although you wouldn't be there, which would be kind of a drag. You're kind of a fun guy, and I think your wife and children, child and child to be, love you a whole bunch. So, Michael, thanks again, and I'll be speaking to you very soon.
Sounds great, Jeff. Thanks. And remember, it's a wild world. Are you protected?